Pnina?
Okay, so I'll introduce myself and it will connect to what I will talk about because I will try to give you some of my personal experience. So my name is Pnina Sharvit-Baruch. I'm currently a researcher and the head of the Law and National Security Program in the Institute for National Security Studies in Tel Aviv, the INSS, which is a think tank, policy-oriented think tank, not a legal body. Most of the people there have come from security, diplomacy. Many of them have backgrounds in the government, or working for the government, or in the IDF, and some come from the academia. So it's combined, combining those elements. I'm there since 2012. Before that, I taught international law for 3 years in the law faculty in Tel Aviv University, and for 2 years I gave a seminar also in the law faculty in Tel Aviv University on the legal aspects of the Israeli-Arab or the Israeli-Palestinian conflict. That's all what I did since 2009, but most of my adult life still, it's changing, but was in the IDF. I studied law right after high school. Usually in Israel you go first to the military and then you go to university, but we have what we call the academic reserve. Robert did the same, so you can postpone your military service, go to university, and then work in your profession already in the military. So that's what I did. I studied law in Tel Aviv University, and then I joined in 1989 I joined the IDF, and I joined a department called the International Law Department, and I stayed there actually from 1989 until 2009. It's a few abrupt pauses for maternity leave, etc., but otherwise I was there for 20 years. I started as after an officer's course as a second lieutenant, as a lieutenant, and I ended there as a colonel. I'm a reserve colonel, and I was heading the department. I headed the department from December 2003 until the end of January 2009 when I retired. In his last role, Robert was in this department too. So. Now, in my military service, if I have to conclude it in 2 words, I would say it's like the heading of Tolstoy, just in the opposite order. It was peace and war. I entered in 1989, and my first thoughts, this was a period when we had what we call the first or Intifada, which was an uprising, but we were also controlling the West Bank and the Gaza Strip was under a military administration and a civil administration, so we were controlling all the spheres of life of the Palestinians. This is before the Palestinian Authority, so I was both involved in giving legal advice. Our department was involved in giving legal advice on all the governmental aspects of running the lives there. So I was dealing with taxation and insurance and property law for the Palestinians under the legal regime that applied there. But at the same time, we were also, as I said, this was the first uprising, so we had a lot of security incidents, and we were dealing with all kinds of military measures, security measures to stop the disturbances and the violence. So I was also in charge of dealing with, for example, issues relating to the rights of prisoners and detainees, and these kinds of questions. So that's what I did in my first few years, but then in 91 already, I had the good fortune of being called to start preparing. It was very secret at the beginning, to start preparing files for potential talks with the Palestinians. This was prior to the Madrid conference, which was in 1991, but it was still a secret. Then we started having negotiations. in 1991 with the Palestinians. I wasn't a member, the talks were in Washington. I wasn't a member of the delegation. My then boss, the head of the department, was Achaz, but I was preparing all the material and the files, so that we did that for a few years. Those negotiations didn't go anywhere, but at the same time, what we didn't know, that in 93, 92, 93, there was a secret track, what's called the Oslo track, that was held between NGOs going on to eventually officials, which led to the DOP, what we call the Declaration of Principles, that was signed in 1993. And after that, what started the Oslo process, and then I became a member of the negotiating teams within this process with the Palestinians. So I was in the first dealing with as a legal advisor on civil issues, on the agreement that was then the Gaza-Jericho agreement, which was the first of the, and then economic issues. I was a legal advisor. I was in Paris, concluding the Paris Agreement, which still applies today in the relations, the economic relations between the Palestinians and Israel, and then the civilian aspects of the interim agreement, the main agreement of 95, and then I continued being involved in negotiating negotiations with the Palestinians after, since then, the Hebron Protocol, the Y Memorandum, Sharem, and the talks on permanent status. Also, I wasn't in Camp David, but I was there again in the preparing the papers, and then negotiations around the disengagement. So what I did for quite a few years was mostly negotiating with Palestinians. I also, a few months, was in the track with the Syrians. So I was a legal advisor of the Security Committee with the Syrians in Shepherdstown. So that's my peace part of my, which I won't talk about here, because I will talk about the second half, which is more what I said, war, or armed conflict issues, because in the end of 2000, when after the failure of the Camp David summit, we had a burst of violence, which escalated, and it became a very intense campaign of terrorism attacks, especially in the years 2000, 2001, 2002. We're talking about in the peak, like 2001, 2002, we're talking about terror attacks on almost every second, third day, with buses exploding, malls exploding, shops, people were not going out to anywhere, except, holding all the events at home. This was really a very intense, and this was quite a long period. And in this period, we, as the legal advisors, were asked to give our legal advice on the different measures that the IDF can employ in this situation. And this brings me to the topic that I want to discuss: is what is the legal framework, and how do we apply this legal framework to this kind of situation. So again, now I'll go back. So as I said, our legal advice throughout the years, like in the 80s when I started, and beforehand, was when we had security or military-related events in the West Bank and the Gaza Strip, to treat it as under a framework of law enforcement, using all kinds of arresting people, detaining them, security measures, administrative security measures like administrative detention, but everything under the rationale of law enforcement, and the laws of belligerent occupation that gave us a framework of authorities. In the end of 2000, the beginning of 2001, and this was a civil. In the 80s, it was an uprising. There were people, there were guns, they were throwing Molotov cocktails and stones, and here and there they were also firing at soldiers. But this was the level, and here and there were attempts at terror attacks. But this was the level. When we're talking about the end of 2000, 2001, the situation was different. Following the agreement, the interim agreement, the IDF left the main the areas, the populated areas, the towns. It redeployed outside the Palestinian centers, so it wasn't there. There was already a Palestinian force that had weapons, and there were other weapons in this area that were, so we had all kinds of armed elements in this area that were using these weapons. And also the level of attacks was much higher, with hundreds and thousands of casualties on the Israeli side, with a very intense terror campaign. And then we were asked by the commanders, and they said, look, we want to do things, we need to take all kinds of actions against this terror attack, but we cannot just go in and arrest people and detain people, and using the measures that we have now is just not enough. We are outside the towns. We don't, at that time also there was no attempt to re-enter the center of the towns, so we don't want to re-enter, that's against the agreement, and also if we do, there will be very violent clashes. What we do have is very good intelligence about the situation in the area, so what we want to do is to use the Air Force, and we have very good intelligence about who are the masterminds behind the terror attacks. These are suicide terrorists, so getting at the end of the level to catch the suicide terrorist just before he explodes is too late. Even getting to the chain before the person that drove him there or supplied him with is too near to the occasion. We can't wait until then, and that also won't stop. That will stop one terror attack. But we know who are the masterminds, the ones in charge. We want to get to them. That will have a much stronger impact on stopping this wave of terrorism. We also know where they are storing their ammunition or their explosives or creating the bombs. So we want to attack those places and those people. And we want to do this through the Air Force. Can we do it? This was a very practical question. We were asked as legal advisors, what is the legal basis? The reason that they asked us was because they were used to getting our legal advice on all issues and operations that they were carrying out in the West Bank and the Gaza Strip throughout the years. They had legal advisors in the headquarters, on the field, so they were used to asking us. And we had to think of the answer. And we said, well, if we look at law enforcement and the laws of occupation, it's not so clear that you can use the Air Force with an intent to kill the head of the terrorist organization or one of the heads or one of those planning the terrorist attacks. It's difficult to, but we are not sure if this is the right framework. Maybe we need to look at this under a different lens, in a different framework. And then we said, if we look at the level of intensity, at the weapons used, at the way the area is at the moment controlled, and all kinds of these features and others, it looks more, not so much like a law enforcement kind of operation, a criminal operation. It's much more, reminds us much more of an armed conflict situation. So maybe we can define this situation as an armed conflict, not a war in its classic expression, but an armed conflict. And Daniel Reisner was at the head of the department, said an armed conflict short of war. Legally, I don't think it means much, but it sounded right. So we went with the armed conflict short of war. I always said, okay. But so we said, okay, armed conflict short of war. Now what does this mean? Okay, if we go into this armed conflict short of war, now we can apply the laws of armed conflict. But what do the laws of armed conflict say with regard to these questions that we were asked? And more particularly, let's take the specific question of, can we target someone that is in charge, let's say, of terrorist cells on the other side and is sending them to carry out terror attacks? Can we target such a person under this framework of armed conflict? Okay, law enforcement maybe not, but maybe in armed conflict, yes. What is the legal regime applying to that? Now, these questions that we were asking ourselves and writing legal opinions became very critical, because at the same time we also had petitions to the High Court. Our High Court of Justice was used to being involved again in the IDF activities in the West Bank and the Gaza Strip. So while we didn't have petitions when we had the wars, for example, war in Lebanon, the first Lebanon war, except with regard to detention, suddenly now we had petitions also about our operational activity, and including the legality, for example, of killing such a person, because we did carry it out, so we had a petition, so we had to also prepare a very detailed legal analysis for the court. So our first answer was yes, we have an armed conflict situation. We can describe this as an armed conflict situation. This answer in itself was not an easy one, and we got a lot of criticism from around the world. One of those criticizing us was a group of senators coming from the US, who came in the beginning of 2001. And we explained to them our thesis, and they told us, look, you got it completely wrong. Terrorists are criminals. And if you want to combat terrorism, it's under a criminal framework and law enforcement. There's no such thing as an armed conflict against terrorists. This was the US position. I'm reminding you, this was the beginning of 2001. It changed very dramatically later on, but at that time, this was a position. We nevertheless continued with our position. Later on, they changed, as I said, their mind and accepted and even came to learn from us our legal interpretations. But the second question, okay, but even if we frame this as an armed conflict, what laws apply to this kind of armed conflict? Do we apply the rules that we find on armed conflict that refer maybe more to armed conflict between states, or is this something completely new? We have to develop completely new rules. Our position was that while maybe this is not the classical armed conflict, there have been in the past other non-classical armed conflicts between states and non-state actors. This is not the first time. And anyway, since we need to rely on some kind of framework, we don't believe that we can say this is a new kind of armed conflict, so there are no rules, so we can just invent our rules. We will apply the rules that exist in the laws of armed conflict or in IHL, and adapt them to this reality and to this situation. Again, the US after 9/11 changed its position about whether armed conflict against terrorists can exist, but it went in the beginning to a direction that said yes, it exists, but the rules that apply are not relevant, and we will just develop whatever rules we want. So we didn't go that way. Eventually, I think they went back and accepted the way that the rules will apply the rules that exist with the adaptations. So they eventually, I think, adopted our initial position. But so we said, okay, now let's apply the rules. So now let's go to the example of, okay, killing someone from by the Air Force, who we know is involved in this kind of terrorist activity. What are the relevant rules or principles that apply? So the first one would, of course, be the principle of distinction. So we said, okay, when we look at armed conflict, so this is armed conflict. The first principle is the principle of distinction. The principle of distinction means that you have to distinguish between civilians and combatants. Well, let me just ask Ido, have you had already, lectures about IHL? Because there are different levels here of knowledge. So should I?
Everyone knows the basics of
IHL. So I can go to the implementation. So anyway, so the rule of distinction, distinguishing between civilians and combatants. You are allowed to target a combatant. You are not allowed to target or to aim to target a civilian. Okay, but now the question is, who is a combatant and who is a civilian? So that was, of course, a difficult question. Here, what is this person? Is this person who is in charge of, let's say, the organization of terror attacks and has a whole entire group or section of part of an organization under his control? And I'm saying his because they're all men, so I won't say his or her in this case. Is such a person a combatant or a civilian? So here, our position as the state, as the DABLA, the International Law Department, and the state was that it is wrong to view such a person as a civilian, because otherwise we say we will be in a situation where the whole armed conflict is against civilians. So let's say it's more correct to compare and say we have our armed forces, the IDF, and members of our armed forces. The other side also has armed forces. Let's try to describe who are those armed forces, or identify those armed forces, and anybody who is a member of those armed forces is also a combatant. Because a combatant is not necessarily only a soldier in a regular army, but also a member of the armed forces of the other side to the conflict. So if we look at that in that direction, we thought that we could make a distinction and say that those that are members of the security, the military wing of the organization that we are facing would be considered combatants and not civilians, and therefore we could direct an attack under seeing them as members of the armed forces of the other side. To the court we presented this position, but we also presented an alternative position. We said even if we don't view them as combatants and as members of the armed forces of the other side, and they are civilians because we don't have really a standing army and they're all civilians, still we have the law allows to target civilians who are directly participating in hostilities. So then we have to look at who is participating in hostilities. Organizing and sending terrorists and organizing terror attacks is definitely participation in hostilities, because the hostilities are these terror attacks. So we have a participation in hostilities, so we can view them as such. Then we have another component, though, that you can target civilians directly participating in hostilities for such time as they are participating in hostilities. So then we said, okay, this is another element, but now, of course, if we know that at this moment this person is sitting and organizing a terrorist with all his assistants, organizing a terrorist activity, that time he's participating in hostilities. But it's a little bit, as good as our intelligence is, we're not that good. And he might have a day job, and he might not be involved at that moment in planning the terrorist attack. So can we attack him when he's not doing that, when he's sitting in his shoe shop? So we said, okay, for such time as in this kind of case should be for such time as he is a member of the organization in which, and in this capacity is organizing terror activities. So that was our alternative formulation. The High Court of Justice, and in the targeted killing case, there was the first targeted killing case, by the way, the High Court of Justice said this is unjusticiable. I'm not going to deal with it. That was Justice Meltzer. So in the second case, so in the beginning we continued without court decision, but then there was another case. It came to Aaron Barak, and he said the law is everywhere. It is justiciable. Because we said, okay, unjusticiable. Now explain to me our position. So we issued our statement, our position. By the way, this court case, it started in 2002, and the decision was eventually given in 2006. So it took 5 years, and the state had three different submissions. The first one was unjusticiability. The second one gave an explanation of our legal framework. And then the third one, that was 2 years later, it gave again an explanation of our legal framework. And it's interesting for anybody interested in the history of how law develops to compare the two. They are very different because in the beginning we were walking in the darkness. There was very little written. We were not experts. I was from peace. Sally had to be an expert in law of war. In the middle, I took 1 year off and started my PhD on conflict. So I started also learning the academic aspect, but also we became more understanding more. But also the main change was that the world changed. Okay, in the middle we had 9/11. Suddenly everybody started writing about it. There was much more written. So there's a big difference between the two papers. The second one, of course, is much better. But anyway, so those were our two positions. The court was reluctant to accept the idea that these people could be defined as members of armed forces and combatants. and said no. We look at it took a formalistic, a little bit definition of based on Article 50 of Additional Protocol 1. If they are not POWs, and this is an international. So first of all, it said it's an international armed conflict, and these are not POWs, so they are civilians. If they are civilians, then we have to go to the DPH. But it did accept that they are DPH, directly participating in hostilities, and it accepted that for such time as is for as long as they are members of this organization, of this of the military wing, let's say, of this organization. So if it did accept the practice that in the meantime was already called targeted killing. In Hebrew, it's called interceptive. Targeted interception, which I don't like the name. I wanted targeted killing in Hebrew too, but I was overruled. So it's called Sikul Memukad. Anyway, so that was the, so we got the approval of the court, also under our alternative framing. In the meantime, we had the ICRC convening a group of experts to deal with the whole issue, not because of us so much, but because now we had, as we all know, the US involved and the coalition forces, so suddenly this question was interesting for others too. So we had the experts meeting on the concept of DPH, direct participation hostilities. I was one of these experts. I wasn't in the first meeting. Daniel was, my predecessor, as the head of the department, but I was in the next 3 or 4. And it was a very interesting group. We had people there from militaries, legal advisors of militaries and of governments, and also people from academia and people from human rights organizations. So it was a mixture of experts. And in the initial meeting that I wasn't there, but when I came in the second meeting, the idea was still that everybody is a civilian. We managed to convince the military, the legal advisors of the militaries managed to, I think, to convince that this is not necessarily, when we went back to our initial position, that if you have an organized armed group that has a military wing, and people that their function is to fight, they should not be deemed civilians, but rather members of the armed forces. And eventually, the guideline or the paper that came out of these deliberations. So this is the position. There are a lot of arguments about what exactly is the definition of direct participation in hostilities, because they did adopt the idea of combat function, what enters into that. But the idea that you have armed forces also in the organized armed group side was accepted. So that was for me also an example of how the law develops. Because we started with, as I said, in beginning of 2001, very little written and a lot of question marks, but with a question that we needed to answer, a practical question. So we took the principles and applied them to the best of our ability, and then the law developed as more and more countries started accepting similar, and then also persuading other experts. And I think today we have even the UN rapporteur on extrajudicial killings, or was it on that? No, it wasn't on that. It was on drones. Yes, it also Emerson, right?
Emerson.
Yes, who also accepted for example, the position that you can view that on the legality of targeted killing. Again, there's still an argument if they are civilians or not, but the legality of targeted killing itself is today, I think, accepted by many, not by all, but by most, I think, of those dealing with these issues. So that's the distinction, and what is the distinction on persons. Tell me if you, how much time do I have, and how much time should I leave for discussion?
Say 10 more minutes. Is it good for you?
Yes. So I elaborated a lot on the people. Of course, there were other questions in distinction, which was objects. Okay, and here again. We have to understand that when we are fighting, for example, in the Gaza Strip, in Lebanon too, but in the Gaza Strip it's even more, everything is civilian. You don't have military almost everything. You almost don't have military objects by nature, military camps, military barracks. It's not like that. Almost everything is civilian. All the activity is carried out from civilian objects. Okay, so it's houses, it's schools, it's mosques, it's hospitals. The headquarters of the Hamas is in the basement of the main hospital in the Gaza Strip, for example, and rockets are fired from schools, from there near the school, and they're stored in the mosque. So the rockets. So it's very difficult to say. Okay, what is a military objective in this case? So here, actually, the law does give an answer, because the law accepts the military objective is also by its purpose or use, and location, not only by nature. So here, I think the law says if you know that they are storing rockets in some place, it becomes a military objective, or if it's the headquarters, it becomes a military objective. The problem here is more not so much in what the law says and how to apply it, but more in explaining the things after the fact. First of all, in making the determination at the time, because you base yourself on intelligence and what you see. Intelligence can be faulty, you can make mistakes, but if you have good intelligence, or you're basing yourself on you saw that the rocket was launched from somewhere, so let's say you at least are convinced that it is indeed the military objective, you as the commander making the decision, it is still very difficult to prove it after the fact. So we have a lot of issues, Israel also with the whole issue of the legitimacy of actions, because what you see after operations, for example, in the Gaza Strip, you see destruction of civilian objects. That's what you see. You don't see the rockets that were being fired from there or stored there, or the headquarters or the militants that were there. And it's the devastation is very makes a big impression, and it's difficult. It's very difficult to explain or prove or disprove allegations on this in this regard. So that's distinction. Now the second important principle, of course, is proportionality, because it doesn't end in distinction. Even if someone is a military target, a lawful target, person or an object is a lawful military target, you still have to take into account proportionality and balance the collateral damage that is expected to be made to civilians and civilian objects. And of course, a lot of the discussion and a lot of the criticism also eventually is on the issue of proportionality or disproportionality of attacks. Here, I won't go into what proportionality means, because it's like a basic tenet of IHL, but of course how to apply it is very difficult. The decision eventually is a decision of the military commander. There are legal advisors. We have what we started creating already in 2000 and in the 2000s, but it was first applied in 2006, and then in 2008, 2009 is a unit of operational legal advisors. This was something that wasn't there, for example, in the first Lebanon War in the middle of the 1980s, and of course not in the Yom Kippur War of 1973 or 1967. You didn't have legal advisors in operational issues. Today, we have legal advisors giving legal advice throughout all the time. I mean, on planning and on issues of methods and means and questions, general questions, and banks and target banks. That's done all the time. But when you have an ongoing operation, high-level intensity operation, you have legal advisors 24/7 with shifts from the headquarters level and government level through the command level down to the division level. We don't have legal advisors beneath the division level. In the US, you have them also in the brigade level. But we have legal advisors, so the legal advisors are consulted. But for example, when it comes to proportionality, the main concern is to make sure that the commanders are taking into account the collateral damage, that they are evaluating, that they are asking for the intelligence that is necessary to make the decision. But eventually, the decision itself, whether an attack is proportionate or not, is the decision of the commander. That's also the standard by IHL, the reasonable military commander. and two different commanders can make two different decisions, and they would both be maybe lawful, even though different. So there's no one right answer and one wrong answer to proportionality. And the last principle, and then I'll open up to questions, or half a principle, but I think it's one of the important ones, is precautions in attack. When that is the obligation to take measures to minimize the harm, to try to avoid, but to minimize the harm to civilians. And here we have this. This includes, of course, the issuing of warnings prior, and Israel issues a lot of warnings, including through phone calls and SMS and pamphlets and warning shots that are also sometimes argued against. But also using which bomb do you use, which method do you use, which angle do you attack from, what time of the day do you attack. All these are means and methods that are taken into account under the precautions principle. So this is what we did during the armed conflict situations. I finished my last 2 months that was supposed to be my vacation talking to Robert were the cost-led operation, and I was in charge of the operation and legal advisors, and then I retired in January 2009. Indeed, it was very, I think, one of the biggest challenges I faced, and most, and I think, as I said, I have my 20 years in the IDF were really very, very interesting, and I had the peace and the war, and I think in both cases you're making very crucial decisions for the lives of many people. And now I'll open to questions.
So open it for questions. We start with Kimberly and then Yali. Whoever else wants to go on the list, just let me know.
Thank you for that. Really interesting, and your experience is vast and impressive. I had a couple of questions for you about the first, the paradigm that might apply, and second, proportionality and how culture might sort of feature in proportionality calculus. And the first was, and I'm going off reports from principally Israeli scholars, because I don't think the decision is available in English yet, but the Israeli High Court decision in Yeshtin. It is available in English.
The Gaza border.
The Gaza border, yeah. So I'm going off their
descriptions.
It's stuck. Yeah. I'm going off their descriptions of the decision, but it sounds like there's sort of a new paradigm that's being proposed, which is a hostilities paradigm that operates in an otherwise law enforcement context, or at some points I thought that I understood that it was a law enforcement paradigm that operates in a hostilities context. In any case, and I'd be interested in your thoughts on both how that sort of fits into the original thinking about a sort of an armed conflict short of war paradigm, but the implications of that as well. And then for the proportionality calculation, just a quick question about sort of what role force protection plays in that calculus, but more sort of whether or not you think that there's a cultural element in engaging in that calculus, particularly when you're dealing with a country that has conscription. So when everybody's children are going to be IDF, does that change the nature of the force protection element in a proportionality calculus?
Okay, so two excellent questions. With regard to the paradigm, yes, I think, and there's an article that Kretschmer wrote already, David Kretschmer in 2000s, I don't remember what year exactly, around 5, on these combined situations. I think one thing that is very a complicating factor in these kinds of conflicts that are a mixture of an area under your control where you have elements that are fighting, but also elements that are maybe just creating disturbances. And this is not something new. I mean, it was there in the past, is how do you really, and in the West Bank we had it for a long time, this limbo situation also. It's a kind of limbo situation. It's not exactly an armed conflict classical, where you are in the enemy territory and you're fighting, and but it's also not exactly only law enforcement, because you are facing maybe crowds that are maybe dealing with disturbances, but you can also be at the same time direct attacked by military components that are also there, or components that have military capabilities. And I think this is really an under-researched field. So if anybody is looking for a topic, because the truth is that eventually you use both. The forces are actually shifting the way they deal with the situation between these two kinds of paradigms. Factually, that's what they're doing. It's the same, by the way, in the coalition forces in Syria, in Iraq. Also, you had these kinds of dilemmas where you're fighting Daesh, but then you can have a civilian disturbance of people. And again, how do you deal with these while you're dealing with this? And it's not the same. So my answer is that I think that eventually the relevant rule that you use has to look at the situation that you're facing at the moment, and the threat that you're facing, what kind of threat it is, and act accordingly. Now, the law has a very difficult time with this, because the law, it has to be an either or, and then you say you're muddling the situation, you're complicating the situation with the soldiers. No, the situation is complicated. To try to make very easy and clear-cut rules to a complicated situation is more complicated, in my view, than to accept that the situation is complicated and the rules have to adapt accordingly. And whether we see that it is done in the fact is in the ROEs. The rules of engagement, because eventually the soldiers, they are not applying this framework or that framework, they are applying their ROEs. Okay? So in the rules of engagement, they tell them, okay, if the person is a demonstrator, so you can't use any kind of force, maybe smoke or tear gas, let's say, to make them go away from. If the person is trying to harm the fence or come near, so you can use these kinds of measures that are more in a law enforcement kind of rationale. If the person, you identify it as someone who is an armed member that is trying to kill you, or not even kill you, because if it's self-defense, it's self-defense, okay? But it's...
That's what I was going to ask. Do you think that the paradigm potentially collapses at some point into sort of individual or unit self-defense?
So I think it's wider. To be frank, I think it's wider than self-defense, because still we are in a situation of armed conflict with the Hamas. So the rules, I think, would allow, and I don't know what the current rules of engagement are. So,
and I don't think they were made.
No, they are not public. But I think I could legally accept that the rules would allow more freedom of use of force against someone that is identified as a member of the armed forces of the Hamas, even if he's not posing a concrete danger. So I would think it would go wider than the self-defense.
Do people make that determination themselves? Is it? I guess my question is more sort of if it doesn't collapse into unit or individual self-defense and it's broader, what is and we know that we have a complicated situation and you want for the legal framework to respond to the complications on the ground rather than trying to sort of ignore them.
Yeah.
It still comes down to sort of individual soldiers making determinations, and the question, I guess, is on what basis would they be deciding whether or not the law enforcement paradigm applies to that person, but the hostilities paradigm applies to this person, if that person is in fact not posing an immediate threat.
The determination would be by those creating the ROEs, and there you have legal advice, okay? So here, and Robert can answer it, because
in the ROEs, in some cases they go to a high level, the decision making. So it's not something that they are only when the ROEs are written. It goes also in the implementation of these ROEs.
Yes, so the implementation in situations where it's not clear, not vague, and it's not clearly self-defense, so it would have to get authorization. And when you go up to the higher commanders level, you also have sometimes the legal advisors there. So, But eventually, for the soldiers, at the end of the day, it's what are their commands and their ROEs, not it's not that the soldier sits and says, oh, is this legal framework applicable? Is this legal framework applicable? Now, the force protection and proportionality is, of course, a very pertinent question that is asked a lot. I think my personal view, and here I think it's linked very strongly to Robert's PhD, so he can add, is that it's the cultural element is relevant, but it's not that because of the cultural element, force protection can get more weight than in some place where soldiers' lives don't count, and that's just as a, no. I'm saying it bluntly. Yeah. I think the cultural element is relevant because it's a component of the strategic implication of the threat, of the strategic implication of a soldier getting killed, or even worse, abducted. Okay, and I'm saying even worse. It sounds, but that's the strategic reality. And I'm being blunt. You will afterwards be diplomatic.
There is a specific discussion on this topic, yes. This issue. And there is an article written by Matt Schmidt and John Merriam, determining on context exactly referring to this question. And the controversy, it raised controversy. There was replied on it was a security reply. Oh no, it was a lawfare with
Just
Security. It was
Yeah.
Professor Shani and Amichai Cohen responded that it shouldn't, and
So I'll give you my opinion. My opinion is, my general opinion is that law has to refer and relate to reality, and cannot ignore it. So when I, as a legal advisor, to commanders, have to give them legal advice that corresponds to the reality and to the logic and to the moral values and to the logic, even if they don't like what I'm saying, I can get through to them. If I have to come and give them some legal advice that is divorced from from the reality, including the strategic situation, they won't really eventually listen to me, and rightfully even, I would even say. So I think that if you know, so we can have a legal discussion on whether, for example, how if there is a risk, for example, of a soldier being abducted, what is the proportional response, and is it okay to endanger civilians in order to the lives of, let's say, several civilians, in order to prevent one soldier from being abducted? It doesn't seem proportionate. That's if you look at it. But if you say, okay, but now and if you look at just the military advantage, the narrow military advantage, they say, so one soldier, what big difference does it make to the unit? But when you look at the military advantage, I think under a more logical understanding of it, that links it to the strategic situation, the military strategic situation. So if you understand that, for example, abducting a soldier has a huge strategic impact. It's for the enemy. It's a huge strategic accomplishment. Like, let's say, conquering a part of the country. So I mean, it's clear to everybody that if the enemy is coming into a state's country and trying to conquer a piece of land, then you can send your soldiers and you can fight them, and you can, in order to save this. But it's just a piece of land, but there is here a strategic importance about. So the same can be when you're talking about the strategic importance. If one of the aims of the campaign of another side is to abduct soldiers, for example, and you know that if it happens, it will change and shift the whole situation. It can mean that the campaign will be much longer and much deadlier, and it will mean that things will change. So I think that strategic consideration is a relevant consideration in the military advantage that you take into account in weighing in the proportionality analysis. And that's what is intuitively what the commanders will take into account. So, and I think that I have a problem sometimes with some of the legal analysis that just sticks to this more formalistic, I would say, approach and disregards it, because it's again disregarding a kind of reality that I think then makes the rules. I want the rules to be applied, so I need them to make sense to the commanders. But that's my personal view. I'm less formalistic maybe than others, and maybe Robert can add a...
Actually, I thought Shani and point were right.
So we don't agree.
Yeah, this is something that changes over time. There's a question of equality, and that's the question of someone. So both claims there's logic in both. There's no question about it. The question whether you stress the strategic levels take into account in this when you consider military advantage, and usually the answer should be no. They're probably right of stating that it may damage equality, and by the way, if human life on one side will cost more on the other. So
that's not my point. I don't think that the human life of one side has more value than the human life of the other side. I'm just saying that if you're fighting in general. You're fighting for the. If there was a complete, you're fighting to protect certain people. So inevitably you are attaching more weight to the life of one side than to the other. Otherwise, you can never have any justification to even open a conflict. So that's the reality.
It is the impact, though, of sort of broadening out the strategic objectives potentially too widely as soon as you start sort of broadening out what you measure proportionality against.
So I agree. I agree.
Will you be here on Thursday? I'll refer to that in my presentation.
No. So you have this discussion on Thursday.
I won't be here Thursday, no, sadly.
I agree that there's always the question of the limits, because when you start opening it up, there's always the slippery slope that any kind of consideration will enter. But I think slippery slope is a very important argument, but it can't always be that if it means that in order to prevent something that might be wrong, we will prevent something that is still within the realm of what is okay, because again, you have to give the forces and the government tools that they can work with, and it's so you limit sometimes because of slippery slope more than maybe you think, but it can't be an only consideration.
I think it's interesting. It depends on what people think. I think the role of the legal advisor is the teller of hard truths, or the palatable, so that at least some of the rules are followed. It's a spectrum, basically, and and I think people's views differ very much on this. I prefer telling hard truths, but
I think you tell hard truths, but you want to be heard.
Yeah.
Okay, so you have to also tell them in a way that you also are heard, and if you stick to to being all the time on the safe side, and the safe side legally, you won't be heard eventually.
I'm sorry I'll miss your presentation, but it will be on YouTube, presumably. So
Up to you.
Yali?
I'll be brief. Thanks, Pnina. It's really interesting with your description of how law developed, and I was wondered about the missing word in your presentation. You said combatants or armed forces of the other side, but you didn't say unprivileged combatants or unlawful combatants, which was the argument of the state.
Mm-hmm.
And in this sense, your normative argument was we can't have armed forces in one side and civilians on the other side, but you do accept the right the armed forces on the one side and unprivileged armed forces on the other side. And we know that even Nazis were given combatant immunity during World War II, and here there was a unique definition of who is entitled and who is not entitled to POW status, which is clearly deviates from normative symmetry in IHL. So I wonder first about your normative position in this regard, and relatedly, to what extent, because this whole debate about unlawful combatants is rooted in Ajax. And I wondered, and you mentioned the solution of the ICRC interpretive guidance, and it's based first on defining these transnational conflicts as NIACs. So I wonder, was there a position about the classification of the conflicts initially when you discussed it? Because when I read the submissions, no one suggested that it's an IAC, it was an invention of the court, and so I wonder what were the discussions about the relevance of the legal framework in this regard.
So I think the issue of the unlawful or unprivileged is relevant for, it's the link between targeting and detention, okay? Because in targeting, there's not such a difference. You can be targeted if you're a member of the armed forces or of a state, or a member of the armed forces of a non-state, so it doesn't really, and if you're hors de combat or surrendered, you can't be targeted whether you are of a state or of an organized armed group or a non-state. So the difference becomes the link between, now the court really went, the writings didn't, and that was one of the problems we had when we were dealing with this definition of who's a combatant, who's a civilian, that the definitions were made when discussing detention, and we were interested in the targeting part. So now with regard to the detention, here yes, the state, and we're not the only state, doesn't want to accord POW status to those fighting for not for a state but for an organized armed group. But here you say, okay, this causes an asymmetry, but this is the case in non-international armed conflict. In non-international armed conflicts, nobody claims that there is a symmetry. That in non-international armed conflicts, okay, wait, I'm coming to it. But if it's a non-international armed conflict, okay, if it was, because now I'm talking about, you put also a kind of normative value kind of way. So let's take it, if we define it as a non-international armed conflict, we still have this problem, this normative problem that there's no balance. I think most agree that there is no balance in the non-international armed conflict. The state is allowed to detain, for example, and the other side is not allowed to detain. So we have this imbalance in when it comes to detention. Is there when you are fighting a non-state entity? Okay, so now I think personally that it doesn't really matter if this is the situation when you are fighting a non-state entity. I don't think it changes, of course not the normative part of it, if you're defining this conflict as a non-international armed conflict or international armed conflict. The problem that you have, that you don't accept that the other side is that you don't accept again, you don't see the other side as a state with the rights of states, exists whether when you're fighting a non-state entity, whether it's an international armed conflict or a non-international armed conflict. Now, today, I think most would define this kind of conflict as a non-international armed conflict. Because the definition of, or the differentiation between an international armed conflict and a non-international armed conflict is based a little bit on a formalistic reading of Article 2. I think in the beginning, when there was the developments, there was this great article also of Roy Scheindorf suggesting maybe we should call it something new. I think that was a better way forward, to say this is a transnational armed conflict. It's not civil war, which was what they thought about once in a non-international armed conflict, but it's not an international armed conflict between two states. But this approach wasn't made. So I think that today, I personally think that the determination in the targeted killing case that it was an international armed conflict was wrong. So, because now the only reason to say it was an international armed conflict, that's not the reason that they gave. was that if it's occupied territory, that everything that happens in an occupied territory is an international armed conflict. And I'm not sure that I agree, because if you're facing a non-international, a non-state entity fighting, even if it's occupied the territory, I think the same rules that apply to any conflict with a non-state entity should apply whether it's in an occupied territory, inside your territory, outside your territory. That should have been the differentiating argument. What the court said, now when we started writing, as I said, in the 2001, the whole issue of non-international armed conflict was almost, nobody wrote about it. It was like civil wars, the notion was really that it's a civil war. Civil wars within the country, Colombia, Sri Lanka, that's it. It's not relevant to our case. But we didn't also say that it is an international armed conflict, because we focused on targeting, and we said in targeting it's not relevant. It doesn't matter whether it's this or that, the answer will be the same. The court was very reluctant the court didn't even understand, I think, that the notion of non-international armed conflict, although the law developed in the meantime, but it still didn't develop yet, its knowledge on it. So it gave, I think, an erroneous definition to international armed conflict. It said it's an international armed conflict because it's outside the borders of the state, which is not a definition. I mean, it wasn't. It was a definition maybe in the article of Scheindorf, but not. So my point is that I think that the determination, that's why there was no determination in the court, or the state didn't argue about it too much. The court was really used to international armed conflict, though you could find the rules there, so it was easier to go that way. But what I don't accept is that it's twisting, unbalanced to say that only one side has right to detain and the other side doesn't, or if you think that it is so it should be so also if it's defined as a non-international conflict. You can't say it's just in the international conflict situation.
Thank you, Pnina. It's very, very interesting to hear much of the things that we read about in this historical context. You spoke a lot about the role of the military lawyer's view as a military lawyer in developing the legal framework and the legal principles by which the state can target members of terrorist groups. And I'm more interested about the implementation of those rules. So after you set the legal framework and the legal standards, there is the actual decision of approving someone as a target in principle, what they call in the U.S. Compiling a key list. And I'm wondering whether and whether you have a role and what was it, if you did, as a lawyer in this part of the decision making. When the Shabak, the ISA brought evidence, brought materials about a specific target, there was this process of evaluating whether or not it is a legal target. Did the lawyers have a role in that? And if so, what was it? And if they didn't, do you think they should have a role in this part of the decision making? A completely different question, just about your opinion about the current rules of engagement with respect to the recent case about the Gaza demonstrations. Do you think that the state should release them, should disclose the rules of engagement, or do you think there are good operational reasons for keeping them privileged? And one final question, just from my curiosity. Were you surprised that the Supreme Court took the target killing case back then in 2002? And if you did, do you think that it would affect your development of the legal framework if you saw that coming?
Okay. So, first of all, about the targets. There are two kinds of targets. You have pre-planned targets that are planned in advance. You have what we call target bank, there's a different name. The UK legal advisor said a different name, and it's a better one, but I forget, so I call it target bank. And there you have these pre-planned targets that are prepared even not during an operation, even beforehand. The intelligence is gathered, and then you have a whole session with experts, Air Force, munitions, and you have also the legal advisor is part of the process. And you have today it's computerized. When I started, it was still Havers, but you have like a page, let's say a computerized page about each target with photos, all the details, including the legal opinion. So you have it's changed, or it's still the same?
No.
It's the same. So the legal advisor is involved in, and if the legal advisor will say that this is an unlawful target, then it will be taken out of the target bank. The legal advisor can say it's a lawful target. The legal advisor can say it's a lawful target under these conditions. So, and then you have the conditions. In some cases, the legality of the target is more, let's say, less clear cut, yes, or they're not sure about it. So then you would have discussions going up to higher levels and up to the legal attorney general level, especially on I would say groups of targets or kinds of targets and the legality categories of targets. I can give, it's easier for me to give the US example, but for example the targeting the Daesh petrol and oil infrastructure that was serving as for fighting. So it's a kind of supporting, it's not a military, clearly military, it's how do you call it? War sustaining. So war sustaining and this is one example. Examples of war sustaining kinds of objects are always more controversial. So you would have a higher level of discussion.
So you have similar.
So yes,
debates?
so that's then you have what we call Then you have immediate targets, and these are ones that during an operation you have immediate targets coming up through intelligence that is gathered or from what people see. Here it's shorter circles. In some of them there is also a link. If it comes up to the division level or to the tax cell, where you do have legal advisors. So the legal advisor. We don't have. So in some of them you have the ones that are, it depends.
When you prepare,
but okay, so if it comes through the shorter circles, you don't have usually a legal advisor in the loop.
So a shorter circle will be a guy coming out with a rocket launcher.
Yes.
You identify.
Yes,
but
yes.
We have like the attacks, so they have ROEs, which when written, they have legal advisors all over it.
Yes.
The only criteria is.
Yeah, so the criteria is there. So they know that if you have a place where you have rockets being stored, so it's a lawful target, and you don't have to. Now there is a specific place that now they saw that there are rockets there. They don't need the approval of the. If it's again a more controversial kind of target, then it would or should at least come to deliberation with the legal advisor. So that's the second point about the ROEs and disclosure of the ROEs. I think it's a problem to disclose the ROEs because they are operational reasons. You don't want the other side to know exactly what your ROEs are, because then it makes it easier for them to manipulate the ROEs. So I think most, if not all, militaries don't disclose their ROEs. So it's not also unique to the IDF. With regard to the, what was the first question?
Were you surprised that the court?
Was I surprised? No, I don't think I was surprised. I was actually more surprised with the decision of Meltzer to say that it's unjusticiable. because we were used to the court being very involved in all operational activity. So that was the surprise. And when it came to Barak, I think most of us were not expecting it to. We prepared the brief on the unjusticiability and at the same time also the brief on the case itself. So it's not as if we waited and were expecting. It was, Aaron Barak was very known for almost never taking or accepting the non-justiciability argument, so we didn't count on it.
Elad?
Yeah, thank you so much for this interesting presentation. I was wondering first a follow-up about the character of your adversary. It is important whether you fight against a state or non-state actor, specifically for your evaluation of what is the meaning of just cause, or in bello, what is the meaning of military advantage? Because if you, in a regular war, I don't think that there is any account that will justify the killing of, for instance, 50 civilians in order to prevent the kidnapping of one soldier. Not even the killing of this individual, but only kidnapping this individual. I have one ad bellum and two in bello questions. I thought that, do you know, with your expertise, if there is any discussion about the changing in the meaning of military victory, if there is a notion in the army, in the IDF, according to which the complete military defeat of the enemy is a justified legal aim of the war or of the military campaign. In bello, do you know whether there is whether the law or international law, as you interpret it, is there any consideration of other elements of costs and the benefits outside of killing and wounding or civilian infrastructure or other elements of well-being? And
Again, could you repeat the question?
Well-being, like
no, but what's the question? If these considerations are what?
For proportionality evaluations.
Okay.
My third question is, how do you treat the notion of risk? Because the way I see it, proportionality, in bello proportionality evaluations are closely related to the meaning of risk assumption and risk imposition on civilians, and how and whether, and if so, how this calculation, the risk taking of soldiers fighting in urban areas is being taken into consideration in bello tactical proportionality evaluation.
Okay. So first of all, the first question, if it's a state or non-state, what difference does it make in the considerations? I think it's not necessarily if it's a state or non-state. Each conflict, even if it's state A or state B, or non-state actor A or B, the conflict and making the determinations is based upon the factual situation of that conflict. So I don't think that the main difference is whether it's a state or not a state. It can be a failed state maybe, or a group that is very well organized and controls an area that is more like a state, and the failed state is more like a non-state. So I think, again, what I said about the kidnapping, it's really the fact of how so here we differ on strategic considerations, what is there, or can they be taken into account. I think that they are being taken into account. That's why I say because they are being taken into account, so let's, instead of just ignoring them, let's put them into the framework of and control them. That's my so you have different strategic considerations. If it's if you are worried about, I think, let's say if the UK and Argentina are at war, so maybe they are less worried what will happen to their soldiers if they are captured by the other side than if you are fighting Daesh, and you might be more worried about what will happen to your people captured by the other side. And I think it's legitimate to take that into consideration. That's what I'm saying. I don't think. I, by the way, don't think that to save one soldier you can kill 50 civilians, by the way, even if it's a non-state actor. So it's not, I don't think that would be proportionate anyway. But I think, yes, the considerations are linked to the specific facts of the specific conflict. Now, military victory or defeat, I think today is it's a terminology that is, and here I'm speaking more on the strategic level, and I was a member of all kinds of groups working on the security, תפיסת הביטחון, security concept of Israel. So today, people are not talking already in the terminology of military victory or defeat or complete defeat of the enemy. I think the conflicts that we are facing today around the world, not only us, in general, usually don't end with a very clear-cut victory or defeat. So it's more a kind of balance of gains and losses. And that affects, I think, the strategic thinking. And so also eventually, since I think strategic thinking affects also the legal thinking, so it would also affect the legal thinking. In proportionality, first of all, the damage to a civilian object is also part of the proportionality. It doesn't weigh as much as lives of civilians, admittedly. About the far-reaching or reverberating effects. So here there's a legal question: how do you need to take them into account or not? I have a more or less, I would take the U.S. Position that it's not legally, you don't have to take into account all the reverberating effects. But I do think that it is if you for example attacking a hospital, you're allowed to attack a hospital, by the way, after you give a specific warning. So it could be, and if it's proportionate, which usually it's difficult to attain, but let's say if it is. So you can take maybe into account also what would it mean if you leave them with no other hospital, or if you're attacking one thing that was taken consideration, for example, if you're attacking targets in the area where you have the sewage facilities, and that will mean that the sewage will burst out and it will cause sickness. So these considerations were taken into account. Whether they were legally, you had to take them into account legally or not, I can build most arguments. Those arguments, again, being a pragmatist, I think you need to take them into account, but they have maybe a limited weight. I don't think it's right, because again, I don't have a problem to say that you should take them even legally into account, because they are in any case taken into account. So I go with what is logical on both ways. Sometimes it means that you take more limitations than maybe the law provides, if that's the logic of any way of the. And the last question was on the risk. So risk, again, the risk enters into what I said before. It's part of. I don't think that it's. I don't accept that.
Because as you know about Benny Gantz, which is the commander of the IDF, former commander of the IDF, he spoke publicly that he put in danger troops from Golani, which is an infantry brigade in the IDF, and it made a whole commotion about it. But I think it's obvious that soldiers.
I agree. I don't accept this position that we can. Take any measure in order to avoid any risks to our soldiers. I don't think that's legal. I don't think that's moral. And yes, you have to take certain risks. That's part of being a soldier. And So I think it goes into the balance, but it's not that I don't accept that proposition that riskless to efforts you can with any price to the other side. I don't accept that. So.
Last on our list is Sophia.
I think I will be quick. I know that Israel has committed a number of targeted killings, not only in Gaza and Ramallah or Lebanon, but also in Egypt, Tunisia, Italy, France. And my question is...
Egypt, I don't know. And Italy and France.
And my question is, what kind of legal framework will apply there? Does Israel still argue that it's part of an armed conflict, or does Israel have a different legal framework to justify these operations? And more importantly, the killing of the civilians that will be the collateral damage during these operations.
Well, the short answer is that all kinds of clandestine operations, whether they are or not carried out by the Mossad, for example, or not governed by legal advisors from the military. So, and they do have a legal advising apparatus. I don't know how much it's involved in these decisions. I think it would be a different framework, but I don't. Since again, usually countries that are involved in all kinds of these kinds of operations don't take accountability, don't accept accountability to these kinds of operations. So unless it's I think if it's a case of someone that is like the Bin Laden case, I think is easier because he is the commander of the forces that you are still fighting against. So then I personally think that the geographical, I don't necessarily accept that the armed conflict is all over the world, but I do think that the fact if you have someone who is targetable, even if not in the active front, or how is it called, the US term?
Battlefield.
Yes, I don't think that in itself means that you cannot target. You have to take into account also then other considerations of the sovereignty of the place where it is, and it's another additional set of considerations. But IHL-wise, I don't think it changes the equation. With regard to other kinds of cases that are not part of an armed conflict, so again, I think this is one of those issues where the law is still somehow less involved. Maybe that will also change. But
do you know whether there are legal advisors for these operations as well?
I don't know exactly historically. In the past, I presume not. Today, I don't know.
Okay. Thank you very much, Pnina. And time for lunch.
We have falafel outside.